Oh my, do you remember Reddit v SerpApi, where Reddit sued Perplexity and SerpApi? Even though Reddit doesn't own the content of its posts, the users do. And even though none of them scraped Reddit, Google scraped Reddit, SerpApi scraped Google scraping of Reddit, and Perplexity used SerpApi's data. It's stupid, it's ridiculous, but it's the SDNY, and we've got the judge's response to the motion to dismiss, and well. But like I said, it's the Southern District of New York, the district that brought you Martha Stewart, the district that brought you Ross Ulbricht, the district that brought you Universal v. Corley. Yes, these guys are very much in bed with the political elite and the content cartels, and this is a really long decision. It's 63 pages. We won't go over that much of it, because all throughout, most of this long rambling is just him spewing the propaganda about the DMCA when it first passed. Back when they were trying to sell it both to the public and to the artists. And if you're not aware of that, just read this. You'll see all the propaganda. And we know it's not true today. Many of us have lived for decades how not true it is. I was one of the first when I got kicked off of mp3.com for singing source code in the form of a square dance call. For no other reason than it was the code that the judge in Universal v. Corley didn't like and ruled that code isn't free speech. And, of course, more recently, I and so many others have had to deal with all of the DMCA crap. So yes, we know it's not true, but this judge is pretending it is. So either he's fully bought into it and he's a true believer, or he's part of the corrupt regime. So no, don't expect much. I'll go ahead and spoil the ending for you. The court grants the motions to dismiss the Section 1201B claim against SerpApi and the unfair competition and unjust enrichment claims against both defendants. That's not quite the victory you might be thinking it is. The court otherwise denies the motions to dismiss, and that's going to be the bulk of the case there. So Reddit says that all this scraping nonsense harmed them. Reddit alleges that it has been harmed by defendants' conduct in various ways. First, Reddit alleges it has suffered reputational harm. What reputation? Insofar as unauthorized access to Reddit content undermines Reddit's promise to users to safeguard their content. Reddit users, do you feel like you've been promised that? Including by protecting their anonymity and not publicly displaying posts that users have deleted. What does that have to do with the DMCA? Second, Reddit alleges lost profits from defendants not entering license agreements to use Reddit content, even though it's their users' content, not the Reddit content. And loss of commercial opportunities because defendants' conduct will discourage entities from abiding by existing licensing agreements or entering new ones. Third, Reddit alleges harm to its property based on unauthorized access to its structured data. Fourth, Reddit alleges it has been forced to invest significant resources in anti-scraping and security measures to prevent unauthorized scraping and use of Reddit data, which is public, and it was decided long ago that if it's public, you can scrape it. That's part of how the internet works. That's a vital part about how so much of the internet works. Alright, this judge actually believes, apparently, these allegations of harm to the reputation of a corporate custodian of users' posts are entirely plausible. With a straight face, apparently. To be sure, as SerpApi notes, the FAC does not identify any particular user who to date has stopped using Reddit because of SerpApi's activities. But evidence of past injury is not necessary to show the likelihood of future injury required for injunctive relief. Yeah, who cares if it hasn't happened in the whole many years that Reddit has existed? Hasn't happened once, but it's gonna, just you wait. Yeah, that's how corruption works. That's how it works. That's exactly how it works. So, Section 1203 states, any person injured by a violation of Section 1201 or 1202 may bring a civil action in an appropriate U.S. District Court for such violation. Now check this part out. The plain meaning of any person injured is that anyone, not just copyright holders can bring a DMCA claim if their injury falls within the ambit of the statute. So you don't even have to be the copyright owner to file the DMCA claim. How about that, ladies and gentlemen? Yes, boys and girls, he says, that is supported by comparison to the Copyright Act, which authorizes only the legal or beneficial owner of an exclusive right under a copyright to institute an action for any infringement of that particular right. The DMCA does not contain such a limitation. But as the judge later acknowledges, the DMCA is part of the Copyright Act. And I mean, this idea that you don't have to be the copyright holder, if it's not true, and I don't see how it could be, then we're dealing with the most corrupt judge we've ever seen to date. Even more corrupt than Lewis Kaplan, which I didn't even think was possible. I mean, we've seen some doozies of corrupt judges in our time. So this guy is up there. On the other hand, if what he's saying is true, then the DMCA is 1,000 times more evil than we ever thought it was. The idea that this is just open wide to whoever, if they can just show an injury of some kind, that's insane. That is absolutely crazy. Hey, you infringed on his copyright and that harmed me, so I'm gonna sue you. Seriously? Does anyone think that's the way it should be? The DMCA's broad language, any person injured, is a variant of any person adversely affected or any person adversely affected or aggrieved, terms of art that the Supreme Court has interpreted broadly as covering anyone even arguably within the zone of interests to be protected or regulated by the statute in question. But in the terms of the Copyright Act, injured means specifically having your copyright infringed on. Because again, the DMCA is just an extension of copyright law. It absolutely is. It's codified in Title 17. So the word injury means injury to a copyright interest. So if you don't have any copyrights that were affected, then you weren't injured by the DMCA violation in any legally relevant sense. Reddit isn't the copyright owner of user posts. So Reddit isn't the party whose interests the DMCA is supporting here. And Reddit also isn't the owner of the SERPs. Google is. Oh, SerpApi scraped them from Google? Well, then Google should sue. Oh, but it's because of the copyright of the owners? Well, then the owners are the Reddit users, and then the users should sue. What he's doing is he's looking at the DMCA in isolation, and it's considered a bad ruling for a judge to do that, to look at something word by word in isolation without considering the broader meaning of the act it's a part of. The Supreme Court has repeatedly emphasized words take meanings from their statutory context, so consider we've got the DMCA as part of the Copyright Act. Section 1201 repeatedly refers to technological measures protecting copyrighted works. 1201B expressly refers to a right of a copyright owner, and the entire scheme is aimed at protecting copyrighted works. So when you look at this word injured here in the ruling, you gotta read it against the backdrop, not like any business harmed in any way, but as someone whose relevant copyright interests were injured. Because the judge is basically stating that Congress intentionally chose broader standing language than it used anywhere else in the Copyright Act. But nothing like that was ever said by members of Congress when the DMCA was passed. And the judge doesn't reference anything that they said to back it up. He just says, oh, well, see, it just says any person injured, rah, 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 rah. Yeah, that's so dumb it can only make sense to a judge. Reddit thus epitomizes the global digital online marketplace for copyrighted works that the DMCA sought to promote. Well, that's an outright lie, isn't it? The DMCA didn't need to promote that. It was already happening. That was the problem. It was happening, and the content cartels didn't like it. So they went whining to Congress. That's what they were worried about. They needed to control it. Although many of these alleged restrictions relate to users' privacy rather than copyright protections, those interests are closely related. Close enough. We'll allow it. Because we're playing horseshoes, I guess. Reddit seeks to ensure that the only posts that are reproduced and distributed are those that users have authorized. It thereby protects copyright holders' ability to control the dissemination of their works. Yeah, but if the copyright's violated, it's up to the user, the actual copyright holder, to do something about it. Basically what we have here is the judge making an indirect interest argument. He's trying to shift all of the rights of the copyright holders to Reddit and pull back all of the rights of the scraped data from Google to Reddit. What we have here is users own the copyright to their posts. Through deletion controls and access restrictions, Reddit helps users exercise control over dissemination. Therefore, interference with those controls injures Reddit in a way that is sufficiently connected to the copyright interests the DMCA protects. The problem with that is that he's conflating a position where you're protecting copyrighted data with holding the copyright interest. But copyright law is very clear about who gets to enforce this. 17 U.S.C. Section 501 says that the right to sue for infringement belongs to the legal owner of an exclusive right or the beneficial owner of an exclusive right. And notice it's an exclusive right. That means no one else has it. And Congress deliberately did not say anyone who helps protect a copyright. So again, the judge is trying to say that the DMCA is somehow different. But again, the DMCA is part of the Copyright Act. And the judge isn't even trying to make Reddit be the copyright holder or represent the copyright holder or otherwise acting on behalf of the copyright holder. He's saying that Reddit itself suffered a legally cognizable injury because Google's technological protection measures were allegedly circumvented by SerpApi in a way that undermined both Reddit's business interests and its users' copyright interests. And another thing, he says that Reddit thereby protects copyright holders' ability to control the dissemination of their works. But there's a difference between helping someone to protect their legal rights and being the person entitled to sue when those rights are violated. Those are two completely different things. Although Reddit's interests with respect to user content are not the precise ones that Congress had in mind in enacting the statute, oh gee, you don't say. Courts have found the zone of interest test satisfied where the plaintiff's injuries are closely related to the statute's animating concern, and then he goes on to mention some cases that aren't copyright cases. SerpApi argues that, insofar as Reddit's claims are based on defendants accessing and scraping content created by Reddit's users, no court has extended Section 1203 standing to a putative plaintiff with interests as attenuated as Reddit's. Exactly, they haven't, and for good reason. SerpApi is correct that most Section 1201 anti-circumvention claims have been brought by copyright holders and creators of TPMs, groups courts have found within the zone of interests of the DMCA. But it does not follow that those groups alone are within the statute's zone of interests. Seriously? What do you have saying that there's anyone else? And what kind of burden do you think you're placing on them to have to prove otherwise? The DMCA prohibits circumvention of a measure that controls access to a work protected under this title, i.e. the Copyright Act. See, what did I tell you? The DMCA is part of the Copyright Act. What did I tell you earlier? The relevant question is whether the snippets of Reddit posts, which SerpApi and its customers like Perplexity are alleged to access and scrape from Google's SERPs, qualify for Copyright Act protection, not whether the full posts on Reddit themselves are copyrightable. No, the question is whether they have access to it, and Reddit posts are publicly accessible. You just browse to the site and there they are. SearchGuard is unlike the authentication sequence in Lexmark for a simple reason. It does not leave Google SERPs freely readable. Instead, as pled, SearchGuard effectively blocks access by automated users while maintaining access for human users. For this reason, the Sixth Circuit's analogy to a lock on the back door of a house whose front door does not contain a lock does not fit this scenario. A more apt analogy is a facial recognition technology programmed to open the door of a home for residents, but not for other visitors. How much of an idiot do you have to be to think that's an apt analogy? Well, a judge, I guess, that's how much of an idiot. Here's a better analogy. It's like saying you're allowing foot traffic into a place along a paved road, but you're not allowing cars because you put in not a gate, but a speed bump. That's what these are. These are speed bumps. Speed bumps on the way to publicly accessible data. Accordingly, the court finds that, as pled, SearchGuard 1. Requires application of a process to gain access to the copyrighted content in Google SERPs, and 2. Was implemented with the authorization of Reddit and its users. It thus fits the statute's definition of an access control measure. Let me remind you again, SerpApi didn't scrape Reddit. At all. They didn't touch Reddit's site. They scraped Google's scraping of Reddit. That means that even if it is an access control, which it's not Reddit's access control. And also remember that Google tried suing SerpApi and failed. That was in Google v. SerpApi, where you have Judge Yvonne Gonzalez-Rogers. She recognized that Section 1203 uses broad standing language, but she also held that Google had to show the technological measures were protecting copyrighted works that Google was authorized to protect. And she ruled, the plain language of 17 U.S.C. Section 1201A3B makes clear that, for a technological measure to effectively control access to a work, it must, among other things, require the application of information or a process or a treatment with the authority of the copyright owner to gain access to the work. So broad standing alone isn't enough. You have to connect it to an actual copyright interest. So Google can't sue, but Reddit can. Make it make sense. Oh, and what else is the judge looking for support? Yout. Remember, that's the one up in the circuit courts being appealed right now. Epic Games. Oh, Nintendo. Yeah. I'm surprised he didn't add Corley. That SerpApi's tool does not descramble or decrypt, does not remove its activities from the ambit of Section 1201, which defines circumvention broadly to also encompass measures that otherwise avoid, bypass, remove, deactivate, or impair a technological measure. Going back again to Yout. But there are two kinds of technological protection measures, and this at best is a copy control, not an access control. He's just pretending that they're all access controls, because if you remember the difference, if you violate a copy control, you have a fair use defense if you're using that for a non-infringing purpose. Access controls take away the fair use defense. That's what's so terrible about this, and so they're going to try to worm everything into being an access control. That's what Yout is all about. That's the one that wants to make YouTube's so-called rolling cipher an access control. Oh, you can access the video, but you can't download it. That makes it an access control, even though downloading is an act of copying, not accessing. That's what they're doing, and this corrupt judge is going along with it. Accordingly, the court finds as to both defendants, yes, including Perplexity, who never scraped anything, that the FAC has plausibly alleged circumvention of an access control measure. This has got to be one of the most corrupt rulings we've seen. I mean, how can you defend any of this? If you think any of this makes sense or is it all defensible, please let me know how in the comments. Go comment and try and support this ruling, I dare you. Now, he did dismiss the part where they allegedly bypassed a copy control. If a copyright owner puts in place an effective measure that both 1. Controls access and 2. Protects against copyright infringement, a defendant who traffics in a device that circumvents that measure could be liable under both Section 1201A and B. But that has not been pled here. A complaint advancing such a dual-purpose theory must do more than merely allege that, because a TPM prevents access, it also protects the copyright owner's rights. Because that is all the FAC alleges here, the court dismisses Reddit's Section 1201B claim against SerpApi. So basically, he dismissed it, but in so doing, he said it was not a copy control, but an access control. That's not better. It would actually have been a lot better for the defendants if it had been the other way around, if this one had been the one that stood, because they can have a fair use defense to this. And the judge just took that away. He also dismissed the FAC's unjust enrichment claims. Accordingly, the court finds that claim preempted by the Copyright Act. Because if it looks like a copyright violation, walks like a copyright violation, and quacks like a copyright violation, it's a copyright thing, not anything else. So the court dismisses that claim against both defendants. And by the same token, Reddit's unfair competition claim is within the general scope of copyright. As with unjust enrichment, the defendants allegedly achieved such misappropriation through circumvention does not add an extra element to Reddit's claim. It's a copyright thing. So the court dismisses that claim against both defendants. For the foregoing reasons, the court predominantly denies the motions to dismiss. It sustains the claims brought against both defendants under Section 1201A, against SerpApi under 1201A2, and against both defendants for civil conspiracy. Because dumb judges always fall for conspiracy claims. The court, however, dismisses the claim under Section 1201B of the DMCA against SerpApi and the state law unjust enrichment and unfair competition claims brought against both defendants. Yeah, this is going to have to be appealed. I don't know if they want to go ahead and do an interlocutory appeal, but at some point, this needs to go up to the circuits or even the Supreme Court. Because, come on, this should not be allowed to stand. You don't even have to be the copyright holder. Oh, it's not a copyright issue, it's a privacy issue. Close enough. Yep, and speed bumps are access controls, even when the content itself is publicly accessible. This has got to stop. From corrupt judges like Paul A. Engelmeyer. So yeah, in a lot of ways we're getting good news out of these anti-AI cases. And I think we're ultimately going to get good news out of them, but we do have these bad corrupt decisions along the road that we're just going to have to live with until they can be properly appealed or go up to the Supreme Court, or if we can convince Congress to clarify what they meant, even though they said pretty clearly what they meant. It's going to happen, so we'll just have to wait and see how it goes and how long it takes. So thank you for continuing with me on this journey. Comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv keeps me doing this. Any amount you can give, one time or regular support, doesn't matter. Any of that keeps me going. So thanks again. And until next time, stay strong and be free.